right. So yes, thank you for coming to the CLE. Such a beautiful day outside, and I just can't wait for the wonderful weather we're going to have this weekend. I am Abby Brenneman. I've got Tameka Parker, our IOLTA program manager, and Robert Brech also agreed to come from Office of Professional Conduct and help us out with this. This is going to be an interactive presentation, so you do not have to participate if you don't want to, but if you'd like to, there's a QR code on the screen right now that you can scan and connect, and you'll be able to interact with us and answer questions that come up on the slides as we go along. Here are those instructions. So you can either scan the QR code or you can go to menti.com and enter 4315-4607. I'll leave that up for just a second so you can see. We got 11. All right, I think we have about half of people having joined at this point. I'm still going to have the QR code and the instructions are going to be up at the very top where it says join at menti.com. They're still going to pop up on the slide, so I'm going to go ahead and move forward. There are your little avatars. Okay, so just to start off, Arkansas Access to Justice Foundation, for those who are not familiar, we do administer the IOLTA program. That means that you can contact us about opening an IOLTA account. You should contact us if you're closing an account too. You can report issues even with IOLTA banks, and IOLTA interest comes to us, and we use that to fund civil legal aid for folks that are priced out of the legal market. I know some of you know this very well because some of you on this CLE are board members. Okay, so I want to give you a little bit of background on IOLTA. This is very, very quick 3-minute video on the history of IOLTA in North America, just so you have a sense for how this came to be and really what it's meant for. Let me know if the sound doesn't work. It should work though.
The IOLTA movement gained steam in the 1970s. That was a time in our country when we were becoming increasingly aware of our rights as citizens. So the idea of legal aid and lawyers helping people to get their rights was relatively new.
The IOLTA programs came along at just the right time, and once they were established, could provide a funding source for the legal services offices throughout their state and for their pro bono programs that were just taking hold.
The Legal Services Corporation was undergoing some severe budget cuts and political opposition in Washington, and we felt the Interest on Trust Accounts program would help them fund legal services to the poor and to try and meet the tremendous need that there was, and the need was all over the country.
IOLTA has had a tremendous role and impact on providing legal services for underserved people.
IOLTA began and continued because of the concern most lawyers have that there should be equal justice for all.
It was an amazing cohesion of bright, willing, capable, dedicated people to public service with nothing in it for them.
We developed the attitude that we're just going to keep working. We're going to have setbacks as time goes along, but we had more successes than we had setbacks.
One of the interesting offshoots of the IOLTA program, both in Canada and the United States, is the opportunity it provides lawyers as individuals, law firms, and the professional associations to contribute to the public good.
Today, we have Interest on Lawyers Trust Accounts programs in every state and also in the District of Columbia and in the Virgin Islands.
When I think of IOLTA, I think of people who never gave up on pushing this concept as the right thing to do at whatever cost and at the maximum benefit.
Legal Services receives by far the majority of all interest income earned on lawyers' trust accounts participating in IOLTA, But funds are also available at many IOLTA programs for projects to improve the administration of justice and for loans and scholarships for law students.
And that is how this community comes together to try to enhance not only the revenue, but enhance the legal profession and to do what ultimately needs to be done, and that is to make sure that the people who need legal services get them.
I think it has brought the concept of equal justice under the law one step closer to reality.
Okay. I feel like a substitute teacher. Like rolled out the VHS player. See if I can restart this. So, I'm trying to do two things at once. So yeah, that is, as he said in the video, the majority of IOLTA revenue is used to fund civil legal aid, and a small portion of it, and actually it's over 90%, and across the country. And in Arkansas, it's the same for us here. So you'll often hear us mention, legal aid is used to fund civil legal aid, but there is, on occasion, we also will use it to fund administration of justice projects and student scholarships as well. Okay. Okay. All right. So now it is true. Yes. All approved banks in Arkansas remit interest to the Access to Justice Foundation. However, some banks remit more than others. And the ones that do are called preferred banks. And those are the ones that you see listed on this lovely slide here. And so how it works is basically we have our Arkansas Supreme Court rule that tells banks what they're supposed to pay. They're supposed to pay a comparable rate. So that's basically the highest interest rate paid to a similarly situated account. And so these banks have voluntarily agreed to pay above what they would be paying under that rule. And therefore, if you are an attorney out there and you want to make sure that you are getting the best bang for your buck on your interest account, on your IOLTA account, making sure that that it is producing the most income for civil legal aid, then I would encourage you to bank with a preferred bank. And though that list is available on our website. Okay, so jumping into who needs an IOLTA account or a trust account more generally. The short answer is that if you're in private practice, you need a trust account. If you're a judge, government attorney, or corporate counsel, you don't, but it's a little bit more complicated than that. So let's get into the details. The rule says any attorney who handles client or third-party funds must hold them as a professional fiduciary. The funds must be held separate from the lawyer's personal or business funds. And so what are some examples of those third-party funds? Well, it could be prepaid, unearned fees. If you charge a flat fee, that doesn't matter. If you haven't earned it, then it could still be a client fund. Settlement funds, funds to pay court costs or litigation costs. Basically, the bottom line is, unless it's a fee that you have earned, it needs to go in a trust account. There are two types of trust accounts. We've got our IOLTA accounts. Those are the ones that are pooled. That's where you have multiple clients funds deposit into one account. But then we also have individual trust accounts. And so the IOLTA account is designed for when the funds that you receive are nominal and for a short period of time. But as the attorney, you have the discretion to determine what is nominal and a short period of time. Pretty much every attorney needs an IOLTA account who's in private practice. We talked about that. It's very rare that you're going to have a situation where you need an individual trust account, but it does happen sometimes. And again, it's up to the attorney to decide when that's appropriate. And we'll talk about the cost-benefit analysis that the attorney does when deciding whether or not to do that. By the way, you don't need to track the interest on your IOLTA account. That is not something that you're required to do. Some of you already know that because you already have your IOLTA account set up. But yes, we track the IOLTA account We track the interest earned on that account. So individual trust accounts, this is for one client's funds, right? And it needs to be deposited into an interest or dividend bearing account. And the interest is income for the client. So it's attributed to them. These accounts are, like I said, pretty rare. And really what you're going to do, the cost benefit analysis is the interest or dividend, is the financial benefit so substantial that it outweighs the cost of administering an individual trust account, which includes the cost of your time. Okay, so what about opening trust accounts? So first thing you got to do is choose an approved bank, and I hope that you choose a preferred bank that, like I said, listed on our website. Also on our website, we have pretty much every form you could ever need to do anything with your IOLTA accounts. We also have a guidebook that walks through all the basic rules, the fundamentals, basically what is the basis for the CLE. And we also have the links to all of the rules. So Administrative Order number 22, Rule 1.15, everything that's applicable to IOLTA in Arkansas. So you can easily go there to be able to reference the rule that you're trying to, if you're trying to figure something out, you can go there to find the rule that you're looking for. So for the new IOLTA account form, it's something that's completed by you and the bank. You will, sometimes I think actually the banks are prepared for this and they have them available at the bank, but usually I think the attorney actually brings it. So maybe if you have experience with that, maybe put it in the chat so we can hear your experience, whether or not you had to bring the form to the bank or if they provided it to you when you went to open your IOLTA account. But either way, it's something that's completed by the two of you. And so they complete their part, you complete your part, and then it is returned to us at the IOLTA program. Very, very important here. When you're setting up your IOLTA account, you need to use the IOLTA program's tax ID number because we're the beneficiaries of the interest. You don't want that interest to be attached to your tax ID number, to your firm's tax ID number. That's not interest income that you need to be paying taxes on, right? So be sure to use the IOLTA. Make sure the bank uses the IOLTA tax ID number. Now, with your bigger banks, you're not really going to see this be an issue for the most part, but it has happened with some of the smaller banks where whoever was setting it up, they just were not aware and they put a different tax ID number. So yes, use our tax ID number, but please don't use our address because we do not need to get your bank statements. You need to get your bank statements so you can do your reconciliations. We don't need to get that every month. I can tell you that we receive dozens and dozens of annual tax statements at the end of the year. That's fine. We just put them, we put them together in a drawer and we keep them in case the attorney wants to get a copy of it, somebody reaches out and needs it from the law firm. But we don't actually need that. Oh, and then of course, for your individual trust account, you would use the client's tax ID number because that's their interest. This is what the form looks like. It's just super straightforward, one page. Your part is on the left, bank's part is on the right. Okay, now for ongoing trust reporting requirements. This section, I think for this section, we're going to focus on our annual compliance statement, since that is something that I think probably everyone has received by now, at this point of the year. Let me turn it over to Tameka, our IOLTA program manager, so she can share a little bit about the compliance statement and how this works.
Okay. You should have already received your 2026 IOLTA compliance statement. It would have came in the mail with your fee statement. So I'm just going to go over some details on filling that out. Abby, if you want to go to the next page so we can look at the form. This is for all attorneys that do not meet one of the below exemptions. If you have an IOLTA account, you can update your information online by signing into your account. And if you don't want to do that, you definitely can send it to me and I can update that information. In the beginning, confirmations weren't showing up, but they fixed that. So once you enter your information online, you will get a confirmation page confirming that. But if you have questions, you can still reach out to me and I can check it for you and let you know what's going on with that. Now, in filling out this form, if you have an IOLTA account, you're definitely going to fill out the top part. And it's just as it is. You're going to print your name, the firm, employer, the full IOLTA account number, not just the last 4 digits. And you also want to make sure to double check that you're not putting a routing number on there, because I know some people do get that mixed up. And then also list your bank. And these are for the ones that do have IOLTA accounts. Next slide, please. Now, for those of you that do not have an open IOLTA account, you're going to pick one of these exemptions. Exemption 1 is only for, well, not only, but mostly judges, government attorney, in-house counsel, and licensed attorneys who do not practice law. So you would pick that exemption. Exemption 2 is if you primarily practice in another state. So even if you have an Arkansas license, but you're in Texas and that is where you primarily practice, you just pick exemption 2. You don't even have to fill out the top part. And exemption 3 is if you're retired or just inactive. And then just sign it and date it. And like I said, you can do this online or you can send it to me and I'll get it put into the system.
Tameka, I have a question for you.
Go ahead.
Do you get forms that have multiple exemptions selected?
Yes, you should only select one exemption, but I'm able to tell when I look at the form, if you select, let's say exemption 1 and 3, and you're retired, but you do still have your license, I can figure that one out. So I do get those with multiple exemptions marked.
Yeah. Okay, and so I think 1 and 3 are pretty I think 2 is the one that trips up people a little bit more. I will say that the reason why I think that we get forms that have, I think it's usually exemption 1 and 3 that people will select more than one. And like Tameka said, it's okay because we can kind of figure it out. But in the bottom line is you're exempt. But exemption 1 is really for government attorneys, judges, and in-house counsel. It's for people who it's different from exemption 3 because that exemption 3 is you're retired or inactive. So that's how they're different. But I can understand because if you're retired or voluntarily inactive, then you're also not handling client or third party funds. But 2, like I said, is where people get tripped up the most because it's this primary practicing in another state. So let's dig into that one a little bit. Does anybody have any questions? Wait, actually, I think we're going to wait until the end for those. Yeah, and I see there's not a bunch in the chat. So let's just say if you're connected on a Mentimeter, you can go ahead and respond to this. Let's say you work for a Texas law firm, but you primarily practice in Arkansas. What do you think? Are you exempt? Yes or no? Oh boy. Okay, I'm just going to give it like 10 more seconds. Sorry to the 2 folks that marked yes. So the key here is that the Arkansas, this attorney is primarily practicing in Arkansas. And, one way to think of it too is I think that some people get confused because you might have a Texas law firm that handles some Arkansas cases. Don't think of it on the law firm level. It's not whether the law firm primarily practices in Arkansas, it's the attorney. The law firm is not the one that's certifying their compliance. The attorney as an individual is certifying their compliance. So if the attorney as an individual is primarily practicing in Arkansas, then they are not exempt. And they need to have an IOLTA account in the state of Arkansas, 1, and they need to complete the top part of their annual compliance form statement. So like Tameka was saying, this is what it looks like when you log into your online account to update your IOLTA information. I know that there was a problem a few months back or last year where it wasn't showing you a confirmation page, but I think they have that fixed. And one thing you can do here, if you're doing it online, is you can just put the IOLTA account number and the name of the bank, just go in the comment section. That is if you're not selecting one of the exemptions. And if you are selecting one of the exemptions, then you should put "Hi Tameka" in the comments like I did when I did mine. Please do that. Just kidding. But you can if you want to. Okay. A flat fee is still subject to Rule 1.5a's test of reasonableness, right? So this is one that I think trips people up too. So even if you designate a flat fee as non-refundable or earned when paid, you may still be required to issue a refund, right? Or they may decide to terminate the attorney-client relationship. So this is how we recommend you deal with flat fees, is that they be deposited into your trust account and you just make periodic withdrawals. So when a complaint is filed, you make a withdrawal. When discovery is complete, after the trial, etc. And so this will ensure that there's money available in the event that they terminate the attorney-client privilege, or that you have to make a refund for another reason at the end of that service. So yeah, flat fees, an exclusively flat fee practice doesn't necessarily mean that you're exempt from compliance. You still need to have an IOLTA account. And this is how we recommend you go about doing that.
I'll give you an example, Abby, that I've dealt with recently.
Perfect.
A lawyer took a $10,000 flat fee, non-refundable. The prosecutor threw out the case the next day. The attorney didn't do anything, but the attorney kept the flat fee. And that's going to have to be adjudicated whether or not that's reasonable. But I think most people would recognize that that probably wasn't reasonable, and he didn't put anything in his IOLTA account, and he's refused to refund that. So I don't think he would take, I don't think many people would say that that's a reasonable fee in that type of situation, but that's what we deal with.
That's a good example. Okay, we already have some responses on this question. Can you have more than one trust account? Think about it. And also, it's trust account, not IOLTA account. Not that that makes a difference, but I'm just saying. You have 5 seconds to walk in your answer.
So you're saying you were trying to be tricky?
No. Now I'm just trying to confuse people.
Semantics.
I think it's a trick question.
Boom. Okay. Majority of people, I think there's 2 people that are trolling and they're hitting the wrong one on purpose. Okay. So yeah, you can actually have more than one trust account. If you think about it, we talked about an individual trust account and an IOLTA account. So if you have one client and you're going to be holding, $500,000 of their money for 3 years or something like that, or 2 to 4, whatever, you may decide, hey, that's probably worth the setting up an individual trust account. That doesn't mean that your IOLTA account just needs to go away. So I would say that I can't think of any situation where an attorney would have an individual trust account and not an IOLTA account. Does that make sense? Because you have your regular clients, and then you may have an outlier here or there that needs an individual trust account. And then also we have, I don't know what it is, but debt collection law firms, they like to have multiple IOLTA accounts. I guess it's easier for their accounting, but yeah, that's a typical thing for debt collection firms, is to have multiple IOLTA accounts. And so I will tell you one reason you do not need to have multiple trust accounts or IOLTA accounts. And that is if your concern is FDIC insurance limits. Banks have these really handy little tools called insured cash sweep accounts now. And so you don't have to, with one of these accounts, you don't have to worry about everything about exceeding the FDIC limits, right? Because everything over whatever limit you set is going to be swept into another bank, another financial institution in their network. And so everything stays protected regardless of how much it is over the $250,000 limit. We use an ICS account here. Yes, it's a little bit more complex in accounting, but not really. I mean, it's still doable. So yeah, I mean, it's better than having a bunch of different IOLTA accounts. Let's see. Okay. What if I have a trust account? I have trust account funds and I can't locate or identify the owner. I'm going to give you a couple seconds here. This is an open-ended question. So tell me what you think. What is your course of action if you're in this kind of situation? What are your next steps? What are you going to do? And while you're doing that, I'm going to look at some of these comments. Let's see. No exemption is needed if the law firm has an IOLTA account in another state. Based off what I think this question is asking, this is Kara Butler's question, let's see. Okay, so we have a question that asks, no exemption is needed if the law firm has an IOLTA account in the other state, right? So if you're working for a law firm that has an IOLTA account in the other state, but you are primarily practicing in Arkansas, that law firm needs to open an Arkansas IOLTA account for the attorneys that are working at their firm that are primarily practicing in Arkansas. Hopefully that answers this question. Arvest, I will tell you that Arvest pays a good rate. However, they do not qualify as a preferred bank. They do pay a decent rate, though. That was a question that someone had. I know what not to do is what someone said. I love that. Call Abby Brenneman for advice. You can do that. Turn over funds to IOLTA. Yes, but with more nuance, right? With a couple caveats. Notify IOLTA and keep the funds in the trust account. Report to IOLTA program, report to IOLTA. I think you're mostly on the right track. But let's see. Let's go into more detail. Okay, so starting with you can't locate the owner. So you have Zebra Towing LLC was your client, and you are reconciling your account at the end of the month, your IOLTA account, because you keep pristine records and you're comparing your case files and your bank statements and your ledgers and reconciling things on a monthly basis. And this case has been closed for a couple weeks, and you realize you still got $50 that you actually have to return to this client. And so you call them and they don't answer, and you send them a letter to the last known address and they don't respond. Try to send them a check and it's returned. Can you remit it to the IOLTA Foundation at that point? I know I'm sitting here acting like y'all are going to actually answer. I'm just giving you a second to think about it. No, right? Because you got to wait 2 years. And so basically, you make reasonable efforts to locate the owner, make those efforts for 2 years, at least. And then if you cannot locate the owner, then you complete a report of unclaimed funds and you send that report and a check to the IOLTA program, but you also need to copy professional conduct. And that is found in ARPC 1.15C. So if you can't identify the owner, right? So we just talked about if you can't locate the owner. Now you can't identify the owner. It's pretty much the same process. The only difference is that the reasonable efforts that you're going to have to take to identify the owner are going to be different, right? Because with the previous situation where you can't locate them, you can send out a letter because you know who they are, you just can't find them. But in this situation, usually it comes down to there's an error with record keeping somewhere. Somebody put something in there and didn't put it down, didn't make a record of it. Somebody's lost track of something. And I mean, this happens, right? This happens sometimes. Sometimes it happens way to a degree that it really should not happen ever. And sometimes the law firm or the attorney, the solo practitioner doesn't find out until they're going to close down their practice or they have unfortunately, passed away. And the people who are, executing their estate then have to try to figure out what's going on here. But bottom line is you make your reasonable efforts for 2 years, you remit that to the Access to Justice Foundation. Copy professional conduct. This is what that form looks like. It's pretty basic, pretty simple. One thing that we see a lot, me and Tameka, when we're reviewing these, because we get these, I don't know, I mean, relatively regularly. It's not usually a ton of money. Is people will not fill out this last section. So according to the rule, when you're reporting unclaimed funds to us, unclaimed or unidentifiable, collectively called orphan funds, you need to let us know what the efforts were that were taken to find, to locate or identify the owner. Sometimes they'll leave this blank and they won't even attach anything. And so we have to follow up with them and be like, hey, we need this. This is what the rule requires. And really, it's kind of a CYA thing. I mean, you want to have a record of the effort that your law firm took to identify or locate the owner of the funds. Some of you are probably thinking, well, what is considered reasonable efforts? I don't have a 100% clear answer for you on this, right? But it probably is going to depend on the amount of money at issue. Hopefully, if we're talking about $500,000, in the case of, someone not being able to being located, hopefully that's very rarely or never occurs, right? People are pretty motivated by money. So I don't think they're just going to let $500,000 sit in an attorney's IOLTA account if they're the rightful owner. But if it's $50, if it's $25, it probably is not, necessary to hire a private investigator to locate this person. Maybe a couple calls, some letters, maybe look on Facebook. If it's a little bit more, maybe contact some relatives. And then of course, I've got forensic accounting listed on here. These last two are like the biggest extreme of what that would be, in my opinion, it would be something that would be a reasonable effort for a very significant amount of money. But there's nothing that I know of that states, here are the exact cutoffs. This is what you need to do for this amount. This is what you need to do for this amount. It's not super clear, but I don't think it's super complicated. I mean, at a minimum, everyone should be reviewing all available trust account ledgers and bank statements. That one's easy. That one's a given. So some of these questions are silly, but bear with me. Can I deposit my own money into a trust account? I want to know what you think. I think these are anonymous, by the way, just so you know. Oh, very cautious people. Okay, you have 5 seconds. Oh my gosh, how's it 12:39 already? Okay, so I appreciate everyone being very risk averse and choosing no. That's kind of right, but really it's yes, up to $500 for the purpose of paying bank fees. It's not 1,000. It's 500 for the purpose of paying bank fees. So yeah, commingling generally not a good thing. Don't do it. But up to $500 is okay. But please keep track of it, because if you don't keep track of it, you're not going to remember it's in there. You're not going to have a record of it to prove anything. And so, when you go to close your account, 20 years later, you can't get that $500 back. It's probably going to end up in a pool of money that you submit as unclaimed funds to us. So keep track of it. Okay. And for this part, I'm going to go ahead and skip through it. This is just basic stuff to prevent fraud, you guys. Setting up two-factor authentication. I looked through the list of folks, and I know a lot of you that are attending this, and I think y'all are probably good on that kind of stuff. That's probably clear to you. Set up two-factor authentication. And then these slides are just about the fact that just because a check has been deposited into your account and it says that the funds are available, that doesn't mean the check was good. So you need to be very careful and hold on to that for a little bit, because the bank, and that's what this is this is what most banks are able to do. Your depositor agreement, that bank is going to be able to take that money back out. And so what you don't want to do is get a check, deposit it, pull money out based on that deposit. Turns out that check was fake, and now you've overdrafted, and now Robert and probably me now have a letter in our inbox from the bank that says you've overdrafted on your IOLTA account. Don't do that. And then I'm going to skip these questions because you guys already know this. The answer is Florida. If you're paying attention to the video, you know. Okay, Robert, take it from here.
Well, I just want to thank Abby and Tameka for asking me to help on this. To be honest, I've always been a government attorney, and I've never had to deal with an IOLTA, but I'm about to have to deal with IOLTA accounts quite a bit, unfortunately. Just so you know, I came to the Office of Professional Conduct in the end of April of last year. There was a huge backlog of cases. There were around 1,100 cases when I got there. Another 400 cases were filed after I got there last year. A little over 700 cases are filed every year. And we were able to close 1,000 of those cases. And we haven't done a lot with the IOLTA cases yet, but I can tell you there are a number of cases that are under investigation right now. And I just want to really caution people. I think the IOLTA accounts can be a great tool for you to use if you do it correctly, if you do the accounting, if you keep up with it, if you have good records. But unfortunately, that's not happening in a number of cases. And I'll go over some examples. But Abby kind of asked for some examples of IOLTA cases, and I didn't really have one that's not an ongoing case right now. But unfortunately, I think we're going to have probably several examples next year. And I'd really hope that each of you, take the time to keep your accounting right, keep good records, because things happen that are unexpected, and it can cause a real problem. The first one that's happened, and this is something that's happened in Arkansas a couple of times, since I took over, and that's poor record keeping that's exposed after incapacitation or death. We've had attorneys who have become incapacitated for whatever reason. They might have tens of thousands of dollars in their IOLTA account, and there's no way to know who that belongs to. There are no records. They didn't keep good records. Their guardians come in. They can't really tell where that money needs to go to. Best they can do is probably wait for somebody to ask, where their money is. But it's a real problem. But there just weren't adequate records for the guardian to come in and tell where that money needs to go. The same thing can happen in a death. You have a death of an attorney with an IOLTA account, maybe tens of thousands of dollars that are in that account, and no recognition of where that money needs to go to. In that case, if that occurs, and then after a period of time, then that's going to go, to Abby and her group, and possibly that's not the right place for that money to go to. Maybe those were earned fees that weren't taken out. You cannot mix your personal money with your IOLTA accounts, but I think we see examples where that does happen, unfortunately. And so just be careful with that type of situation because you don't know, obviously none of us know when we're going to be incapacitated or possibly die. And you're going to leave a real mess for people to come in behind you and try to figure out where that money goes. And the money may not go where it was originally intended, although it would go to a good cause, I suppose, if it goes to Abby. But that's not really what we want to happen. We've had attorneys that use their IOLTA accounts as more or less a personal checking account or an operating account. That's improper. And let me just tell you, what happens with these. There's a paper trail. I've got a retired FBI agent on my staff that does these types of investigations. He's very thorough. He knows how to look through banking records. And when you do this type of thing and you're paying your electric bill or your phone bill, your personal bills out of your IOLTA account, or purchasing items out of your IOLTA account, that's not the proper way to do it. And you're going to leave a paper trail. Maybe you'll get caught, maybe you won't. But I can tell you, I ran a small business. I was audited. Auditors know exactly what to look for. And I can't imagine, even if it's an IRS audit, that the first thing they're going to look at is your IOLTA account. I can tell you just from the experience I've had, it appears to me, and that's the fourth item on the list, it appears to me that people are using the IOLTA accounts as a tax avoidance issue. And I can tell you, I worked with the Department of Finance Administration before I took this job. I was the state budget director. And I worked with the tax people routinely. And I can tell you, even the Arkansas tax auditors are very good. And if you're doing that type of thing to avoid taxes, it's just not a good way to do it. I'm not saying there is a good way to do it, but you don't want to use your IOLTA account because the records are there, and you're going to get caught up in a situation you can't get out of. The other was, blending personal IOLTA funds. And we've had situations where not only where the client funds or the client checks are going in IOLTA accounts, but personal checks or personal instruments that belong to the attorney are going into the IOLTA funds. And again, there's really no legitimate reason for that to happen. It doesn't need to happen. But we've got cases right now where for whatever reason that's occurring. So use your IOLTA accounts the way that they were intended to. And I think it'd be a great tool to probably help you with your accounting for taxes and everything else. But if you don't, it could cause you a lot of problems. And none of us want to see that. I don't want to see any more IOLTA cases. To be honest with you, kind of find them interesting because I do have a background in finance and I kind of like looking through that stuff too, as sort of an audit type situation. But I don't want anyone to get caught up in a situation like that. I want to kind of go back and talk a little bit more about the earned, the flat fees versus, non-refundable retainers is what people are calling them. We have a number of situations where people have in their contracts that they have non-refundable retainers. You cannot have that in Arkansas in a client contract. If it's a retainer, it is refundable, whether it says non-refundable. I talked to an attorney just recently. What he had was he would charge $4,000 for the services he was doing. And then once he used that up, he would charge $250 on top of that. And I explained to him, you cannot do that. If you do a flat fee, you cannot charge on top of that. If you do a flat fee, you have to provide the services that you said you would provide. And so, keep in mind you can't do that, but whatever retainers you get should go into the IOLTA account, and you should not take out those funds until you've earned them. We try to stay out of fee disputes for the most part, but some of them are just glaring, and there's no way for us to overlook them or not take some type of action. So be careful with that. When I talked to the gentleman that wanted the flat fee plus, he said he really had no idea about how much to refund the client because he didn't keep any records. So my question for him was, well, if you don't keep any records, how do you know when you use up the 4,000 and you can start charging 250 on top of it? And he really didn't have an answer for that. But if you think about it, isn't that the problem? And he finally just said, well, I'm just not a good record keeper. And I said, well, I can't help you with that. And I'm not sure how that's going to turn out. Again, though, with your IOLTA accounts, if you use them correctly, if you reconcile those statements monthly, if you keep up with exactly whose money that is, you've got a great tool to help you with your practice. I see a question in the comments about the let me get back. Would multi-state firms need to have trust accounts in every state they practice? We're dealing with a case or with a situation right now. Apparently, some states don't require that. Some states may allow you to have an IOLTA account in a different state. But in Arkansas, to be an eligible account, you've got to use an eligible bank. And for that, they have to have ties to Arkansas. And so, as far as Arkansas is concerned, you would have to have a separate IOLTA account here, but not necessarily the case in all states. Just to make sure that that's clear. I'd like to leave some time for questions if anybody has any.
We've got some questions in the chat. So let's go back up here. Since you were talking about flat fees, we'll start with this one. What are best practices for flat fees? Our retainer says earned on receipt or estate planning clients. Did those payments have to go into an IOLTA account? It's a little bit less risk, I feel like, than a case that you're litigating in court, because it's like you complete the estate planning product, right? And that's it. But at the same time, I mean, based on the plain reading of the rule, it's any funds until they're earned. And so until you've drafted the estate planning documents, it needs to go in IOLTA account. What do you think, Robert?
Yeah, well, you don't want to use the term retainer. I can tell you that. When you use the term retainer, that implies that they have paid a certain amount of money and you're going to bill against that retainer. So, if you're using retainer, take that out of your contracts. The situation happens, and I see this from time to time. Somebody comes in, they sign a contract, they're going to pay you $4,000, let's say for estate planning, and they're driving home and they change their mind, or they change their mind the next day. You really haven't done anything yet. Maybe you're very proficient and maybe you've already started, but they change their mind. They want to go to somebody else perhaps. And the attorney says, no, I earned that upon receipt. I'm not giving you anything back. Now you get to in the rule, it talks about reasonableness. And so, what's reasonable? I've always told people that's whatever the judge says it is. And reasonable in the case of discipline is going to be whatever the, professional conduct committee, whatever they say. I'll leave that up to you to decide what's reasonable. I can't answer that, but I think anybody would understand if you hadn't done any work at all or done very little, and somebody paid you a significant amount of money, then that would not be reasonable, even though they may have signed the contract.
Here's another one. If you get okay. What about filing fees? Okay, so if you get a retainer with fees included and you're filing the case immediately, like the next day, do you still have to put the 185 filing fee into an IOLTA. I would think that, I mean, how are they even paying? Because if they're paying in with one check for the whole upfront fee, then how are you splitting that between your operating account, I guess, and IOLTA account anyway? But I would say, I mean, what do you think, Robert?
Well, I don't know that we certainly wouldn't take any action against somebody if they did that one way or the other. But I think just for bookkeeping purposes, if you put it in your IOLTA and then you can put all the funds that you got from that client in your IOLTA and then move it to your operating funds, in a way that's recorded, you can account for all the money. I think that's a much cleaner way to do it when there is a fee dispute. And believe me, there are a lot of fee disputes in Arkansas. Hundreds of fee dispute grievances come to my office. We try to not deal with many of them, but just to keep you out of trouble, I mean, and keep the bookkeeping very clean, I'd put everything in the IOLTA, then take it out.
If they pay you after you perform the services, do you have to put that in an IOLTA account? No. Those are earned fees.
We had one question here in the Q&A. Did you see that one? If flat fees are unearned funds, even if non-refundable, then all client payments should flow through IOLTA filing fees as well, which we've kind of touched on some.
Yeah, and I think we've talked about that for the most part. Just even though you might say in your contract that it's earned, that won't necessarily be the opinion of the committee should you find yourself in front of them. So I would just be careful with that. I do see a question regarding medical bills, and this comes up quite frequently as well, where especially in personal injury attorneys, you end up with the settlement and there's a medical lien, or that there are medical bills that need to be paid. Be careful with that, because we do have situations where the money leaves the IOLTA, it usually goes to the client, but there is a medical lien against that, and you could end up in a bad situation with that. But I would definitely put the money in your IOLTA account and pay those medical bills out of that, and keep a good accounting just to keep yourself safe.
Are there any questions on there that I missed, Abby, that you see?
I don't think so.
Okay. Oh, okay. Somebody just sent in another question. Going from solo practice to a partnership, can I move IOLTA money to the partnership account?
You can, but I would not do that. I would try to reconcile your IOLTA account at your solo firm and then restart at the partnership. But that's a recommendation.
Okay. Well, we have 2 minutes left. Would either of you like to add anything else? No.
Only that I do want to thank everybody for attending, and really I want to thank Abby and Tameka, because I'm going to have to be dealing with the IOLTA accounts much more than I wish I did, and this really helps me, and I hope it helped everybody in the audience.
Yeah, and if you need, me and Tameka are doing IOLTA stuff all the time. And we're in a little bit of a different position than OPC. So, I mean, we can't speak for OPC, but we're dealing with IOLTA. And if you need anything, if you are opening an account and you have questions, you have issues with your IOLTA bank, or you're dealing with, having to figure out how to report your unclaimed, unidentifiable funds, or what you need to do to find their locate or identify the owner, give us a call or send me an email. Abby, it's just Abby, ABBY, at arkansasjustice.org. And our contact information is all over our website too. And thank you,
Great.
Robert. I appreciate you.
Thank you.
Thank you. So before I close out, we did just get one more question. Are IOLTA accounts audited?
Well, I'll tell you from my perspective, uh, as far as I know, they are not, but it's something that I'm considering because we kind of stumble upon the IOLTA cases, to be honest. They're they're typically not reported to us. It's something that we stumble onto, and it seems that it's there are some real problems out there, and I'm seriously considering asking the court to allow sort of random audits uh, because I think they're in need. I wish I didn't think that, and I hope that people do the right things, but I am seriously considering asking about doing random audits.
Great. Well, thank you again. I think that's all the questions. If anybody joined by phone, which I didn't see any phone numbers that had joined, but if I did miss one, please send me an email with your phone number. If you called in by a phone, so I can get you your attendance form. And to all of our other attendees, I'll be sending you a follow-up email to the email you logged in to watch this session with. I'll be sending that very shortly. It'll have the attendance form, any upcoming events we have, and a copy of the PowerPoint presentation. And thank you again for joining us today. Stay safe and warm, and we hope to see you at our next CLE.
Thanks.
Thanks.